All right, well, we might make a start. It's now 12 o'clock, and I said we would make a start promptly at 12. Some people may join us as we progress, but I think we might get moving. So welcome everyone to a webinar on social media and mobile technology and talking about some of the evidentiary impacts. As you're all aware, more and more of this evidence is created every day, and typically courts are not are dealing with it or struggling to deal with it, I guess, in the same way as they dealt with hard copies. So hopefully raise some interest or topics of interest, and welcome any comments you may have. I think, as Grace suggested, if you have any questions, then please type them in, and then I'll endeavour to answer them at the end of the webinar. So what we'll talk about today, I'll just give you a bit of an overview of who I am and who e.law is, talk about what social media is for those of you who don't know, which I'm sure is very few, talk about social media in case law globally, and then smartphone security issues, privacy issues, offences, and any solutions that we can look at. So about myself, I am one of the directors of e.law, which we started in 1999, so coming up to 16 years in business. Had a lot to do with digital evidence over that time, and just drawing on my experience in practice and then working in courts. e.law has been around for over 15 years. In March it'll be more like 16 years, and we recently merged with another company who have been around for a lot longer. So our combined experience, I think, between the directors is something like 100 years, which probably speaks more to our age than anything else. So the services we provide include computer forensics, which includes digital evidence and collection and analysis of evidence, electronic data discovery, so that's actually preparing electronic evidence for exchange during discovery, and of course as that evidence is reviewed and then prepared for witness statements for ultimately the hearing, the next step then is to use tools, which are web-based tools, to review those documents and help prepare evidence for trial, and then of course taking the evidence into trial, which we call electronic trials or electronic courts. So essentially we've been running electronic trials for all of those 15 years. I must say though that are they becoming more common? Probably not. Certainly for document-heavy trials, an electronic trial is run, but for more run-of-the-mill matters, often hard copy is still used. So we actually work to an international standard, which is called the Electronic Discovery Reference Model. That reference model is laid out here, and that's available at the Electronic Discovery Reference Model website, which is edrm.net. Now, the rationale behind this is that as the volume of as the volume of documents decreases, as it's culled and filtered and reviewed and so on, then the relevance should increase. And you'll see that there's the yellow triangle on the left increasing with the blue triangle on the right. So firstly, there's an information management component. So more and more companies are actually looking at preserving their evidence in a way that makes it easy to retrieve. Back in the days when a lot of companies would simply archive the backup tape, meant that it was often a long and expensive and difficult process to retrieve archive material off backup tapes. It's much easier to retrieve information stored on servers, in document management systems, in a way that means that the original information is not changed. So email archives, electronic files. If the company's ever involved in a litigation, then hopefully they can go to the relevant date period, look for relevant project files or files in relation to particular people, and extract those and give them to their lawyers for the relevant review. I think still in the electronic world, we're a long way from having the old manila folders in the hard copy world. And I think a lot of companies are certainly endeavouring to get to an electronic environment which mirrors the old hard copy way of filing things. So that identification means finding information, as I mentioned, either by project, by date, by custodian, collecting that, preserving it if you need to. Processing, reviewing and analysing is, I guess, what we call the e-discovery process, which means that in an electronic repository, a lot of the irrelevant material is discarded so that the lawyers can review the relevant material, analyse it in a way that is relevant to the issues in the hearing, and then produce it to the other side and ultimately present it. So that's the EDRM, the Electronic Discovery Reference Model. It's a standard we work to. It's global and international standard. So to do discovery in the US or the UK, for example, it's all done in accordance with this same standard. So the issue with electronic evidence is that it hasn't been around that long. Probably in the last 20 years or so, email has really only become, I guess, a standard form of correspondence. And I know a lot of lawyers still send things in hard copy. There's still signatures, for example, that need to be applied to hard copy documents, certainly for land contracts and the like. So we're still getting our heads around how to deal with electronic information because today electronic storage is a lot less expensive. There's a lot more of it. Things like cloud computing means that cloud providers can make infrastructure available at a much lower cost than firms could ostensibly do themselves. So the new era of digital evidence, as I said, means organisations can have the ability to store large volumes of data. That data can be exchanged quickly and easily, and I guess there's still a lot of question marks over standards and ways of exchanging that, I guess, in a way that enables information to be captured and put into databases quickly and easily, and I'll talk a bit about that later. And these changes, the new era changes, as I said, have really only happened in the last 20 years or so. So I guess the law in some way just is still playing catch up. The world is now truly global, so I guess a lot of the issues around jurisdiction and sovereignty we have to deal with. As you know, if you're accessing information which is stored on servers in the US, then you've got a jurisdiction issue, and I'll talk a bit about that. So the law hasn't had a chance to keep up, not just locally but globally, and we certainly don't have consistent laws between jurisdictions. I guess the main thing is social media, the cloud and mobile devices simply weren't around 20 years ago, and I guess leading on from that is we don't really know what's going to be available in 20 years that's not available now. There's some question marks on how we deal with those types. Emerging technologies, they're changing the evidentiary landscape. Obviously, the information that they create is evidence. So how do you obtain it? How do you keep the chain of custody intact? How do you authenticate that evidence? I'm sure all of you know what social media is, but just to summarise, it's really any of these sites that allow a community or group of people to come together and share information. So Facebook, Twitter, YouTube, MySpace, LinkedIn, blogs. And I guess the way in which this is done is unique compared to the way it was done in the past, because you've got an area where several people come together in order to create and exchange information. So why be worried? I think everyone's been worried about teenagers who put their photos on Facebook. The information is there forever. The information can be misused. So private information can be used for someone else's advantage, say identity theft. It can be used against people in all sorts of things, such as child custody, defending themselves in case. Also, I guess, there's a lot of discussion in the media about whether our metadata should be retained and used by the federal government, albeit that certain ministers perhaps don't know what metadata is, it is being retained. So that gets back to the big brother issue. Everything that we do online ostensibly can be collected by the government and used. So how is that dealt with, and how are governments ensuring that that information is used in a way that is acceptable to society in a broader sense? Also, there's a lot of negative perception. So even though there's lots of good perceptions around social media, there's certainly a lot of negative perception. And there's a recent study that found that up to 70% of employers in the US have rejected candidates based on data found online. I mean, the information's there, it's available, people will use it if it is there. So Facebook is, perhaps the most well-known and popular social media site, simply because it holds over 1 billion users. So that's what 7th of the world population and growing. Users perhaps don't know what they're signing up to, as their privacy policy arguably is complex and it's constantly changing. So as a user, most people potentially would not go and view the privacy policy. They just use Facebook to communicate with their friends potentially. Facebook's also multi-jurisdictional, so privacy policies that apply in one jurisdiction may not apply in another. And recently Facebook was accused of accessing users' text messages on phones. It denied that it does do this, but acknowledges that it could. So, it does have a lot of power. It does have a lot of information that can be used. And it's a private organisation, a company, it's not a government organisation. So cloud computing, for those of you who are not sure what cloud computing is, essentially the way it works is that cloud vendors will buy a number of, let's say, servers, which are just large computers, for want of a better word. Now, to compare a server that's used inside an organisation, let's say that server had 2 terabytes of storage space. An organisation may only need to use 200 gigabytes, so a tenth of that space. A cloud provider will have many servers, but if it had an equivalent 2 terabyte server, it could chop up that server into 10 200 gig, what they call virtual machines, and rent those out. So it means that as a user, I now don't have to make a capital investment in a server, depreciate that, and then have to buy another server in 3 years' time when it's depreciated and not server machine. I can now rent that 200 gigabytes of space from a cloud provider. If I need more space, then I just simply say to the cloud provider, I need more space. If I need to upgrade my server, I can say to the cloud provider, I want more capacity, more memory, fast processing speeds, and so on. So it allows organisations to move from an infrastructure model where they need to buy hardware up front, and as I said, depreciate that, and then also have the added cost of having staff to run that infrastructure, buy software to sit upon that in order to make it run, and so on. All of this can now be outsourced. So as you can see, that potentially has huge cost savings for the consumer and provides an ongoing business model for the cloud providers. There are many different ways of using the cloud, and anybody who uses something like iTunes all have the capacity to upload their files to the cloud. Google has the ability to upload files to their cloud from the dashboard. You can link all sorts of mobile devices, again using the Apple example. You can have your mobile phone, which can upload or download to and from the cloud, your iPad, your home computer, and so on. It can store your location data, so the GPS coordinates on your mobile phone is stored in the cloud, your search history, your email documents, any of your installed applications, all of that, anything that you want to do on a computer can be operated within the cloud. So why be worried? I think there's a number of issues, and I don't think they're issues that are insurmountable. I think that users just need to be aware of what cloud computing does and how it works. Often users may just click I agree, don't really know what the contract says. And there are a number of things often in cloud contracts which would make a user wary, such as they don't know where their data is stored. It could be stored overseas in another jurisdiction. If it's stored in another jurisdiction, how can you access it if the cloud provider cuts off your access? The contract may actually say that the cloud provider owns your data, so you don't have any access to it whatsoever. Now that could cause issues if someone is trying to discover that information. Now that could be good and bad. If it's out of someone's reach and not in their possession, custody, and control, then it may not be discoverable. Data can be stored in disparate locations. So as I mentioned earlier, if you initially take 200 gigabytes of what they call virtual space and you need more, then the extra 100 gigs, say, that you rent may be stored in another location. Cloud providers also do what they call load sharing. So they may transfer a copy, your 200 gigs, to another server. They may split it up because they need more room on that server. So data's moved around, and the cloud provider's systems always know where your data's stored so they can find it, obviously, but you don't know necessarily exactly where it is. Now, because data is not stored on the user's own hard drive, certain information that computer forensic experts might obtain, such as deleted information, is no longer available. I mean, in theory it might be, but because of the way these virtual machines work, the data is most likely being overwritten very quickly and not recoverable. So, there could be issues there if deleted information potentially has been sourced. So all of this can lead to custody and control issues and enforceability in other jurisdictions. We'll talk about that. So social media evidence, obviously if it's subject to litigation, then there is a duty to preserve it. There's a duty on the user. Just leaving aside all those issues such as custody and control and so on. And that duty to preserve is triggered when someone reasonably foresees that evidence may be relevant to issues in litigation. Now in Australia, there's various terminology. So in Victoria, following the British American tobacco case and the enactment of the Evidence Document Unavailability Act, the terminology is litigation is reasonably likely. In other jurisdictions, it may be reasonably foreseeable. So it just depends on which jurisdiction you're in, but essentially legal practitioners ethically are under obligation to preserve information and to tell their clients to preserve information if there's a reasonable likelihood that they're going to involve in litigation. So how do you preserve social media information? So Facebook offers the ability to download your information. So you can go to Facebook, go to the relevant settings, and then download a zip file which will contain all of the information at that point in time. So as a practitioner, if your client is involved or reasonably likely to be involved in litigation and there's a question mark over social media evidence, then you should instruct your client to download a copy of that. Likewise, if you're on the other side and there's Facebook information that you need for your client, you should put the other side on notice that you'll be requiring that during discovery. Twitter offers a similar, although somewhat limited option. Twitter can download all tweets posted to an account by requesting a copy of the user's Twitter archive. With respect to cloud, these systems are a third-party vendor may be necessary. So cloud preservation and X1 social discovery are two examples of commercially available tools that are specifically designed for archiving and collecting social media. But just, it's always hard, I know, for the to find out exactly what you might need, but just be aware that you may have to ask the client or put the other side on notice that you're going to be requiring this information in discovery and trial. We don't have any cases that I'm aware of in Australia on consequences of failing to preserve, but in the US, in Leicester and Allied Concrete Co., the court sanctioned both the plaintiff and his counsel based on his determination that they'd engaged in spoliation to destruction of social media evidence. In that case, the lawyer told his paralegal to make sure the plaintiff cleaned up his Facebook page. Paralegal helped the plaintiff to deactivate his page and delete 16 pictures from his account. So although the pictures were later recovered, the court found the sanctions were warranted based on the misconduct. So in Australia, again, you could, as a lawyer, potentially be in breach of your ethical obligations under the Law Society rules. If you're found to have assisted your client in destroying information. So I was just being told there that my sound potentially was a bit low. So hopefully that has increased the sound a bit. Can anybody just make a comment that they can hear me better? Marginally better. Okay. I might hold the microphone closer. Is that any better? Okay, great. I'll try and talk a bit louder too, because I do actually have a quiet voice. Okay. All right. Privacy. Do you have a reasonable expectation of privacy? I mean, I think personally, I think this is a very difficult area. The problem is once information is on the internet, it's out there. It's very hard to claim privacy over information when it is publicly available. Now, arguably, Facebook pages are not publicly available unless your settings are such that they are publicly available. The courts say that private is not necessarily the same as not public. So by sharing content with others, even if that's only limited to a number of specially selected friends, the litigant has no reasonable expectation of privacy. And we'll talk a bit more about privacy in a moment. Now, I've talked about the obligation to produce digital evidence, and now each jurisdiction in Australia is slightly different in terms of the wording, but essentially parties may be put on notice or may be ordered by the court to discover or disclose evidence. I'll use discovery and disclosure interchangeably. It's, again, different in each jurisdiction. Now, what is in someone's control, I guess, is the question mark. And I've already talked about data that is with a cloud provider, and the contract provides that the cloud provider owns the data, then you may have an issue. But interestingly, there was some cases last year which specifically looked at control of electronic or digital evidence. Now, they were slightly different in that the matter of Your Response Limited and Data Team Business Media, it went to the Court of Appeal in England. And that case was about a database and whether an organisation could have a lien over a database for unpaid bills. The court looked at this question and ultimately decided that because a database is intangible, it's incapable of being controlled, or incapable of being property that could be controlled. Another case in New Zealand, it went to the New Zealand Court of Appeal. It was a criminal matter where it involved whether, or the question was whether a digital video stored on a hard drive could be stolen. Now the court held there that the hard drive could be stolen, but the digital video on the hard drive itself could not be stolen. Now the court sort of looked at this question and said, well, they had to come to that decision because the piece of legislation, which was the Crimes Act, under which the definition of property came, was recently changed, and it wasn't broad enough to cover digital information, and the court felt that it wasn't up to them to create new laws when Parliament had only just recently made a change. So I took from that the court thought it was ridiculous that property didn't cover things like digital videos and other electronic evidence, but it wasn't up to them to make changes. With respect to the English case, my view there is that a finding that a database is intangible and therefore not subject to being property is contrary to intellectual property laws, where intangible things can be owned and in fact can be transferred. Also, I just think that perhaps what's not being put to the courts is that digital evidence are items, they're capable of being created, they're capable of being owned and controlled, and that this isn't being put to the courts, and potentially, are the courts making the best decisions when information isn't being made available to the courts in order to come up with such decisions. Why is a piece of paper different to a piece of digital evidence? Now, I don't have the answers to those. I just raise that to say that this whole question of how digital evidence is treated by the courts, I think still has a large question mark. But I'm certainly interested in anyone's comments or suggestions that they have with respect to where the courts are headed. Essentially, though, for a court to order discovery or for a court to admit electronic evidence, they will look at whether it's relevant or not. So if you go to the court requesting discovery of a social media site, you have to have a reason for asking for that. So the courts will ask for the usual sorts of submissions with respect to why you need it. It can't be a fishing expedition. You've got to have a good reason. Okay? When a litigant's social networking account is not publicly available, then you may have less of a chance of getting it discovered. Assuming you can show that discovery is needed because it's relevant, then the next question is, how do you get it? Or how do you get the order? A variety of methods, I guess with a varied and mixed degree of success. One of the most intrusive methods of discovery is to permit the requesting party to access the whole account. Now this would be the equivalent, obviously, of granting access to a litigant's entire office. Now, this whole area is interesting, and I've looked at this with respect to, seizure of hard drives, where a hard drive, whether it's acquired by a government organisation such as ASIC or one of the other crime commissions and that sort of thing, or whether it's obtained under an Anton Pillar order. Now that hard drive is going to contain both relevant discoverable material, but it's also going to contain privileged and confidential information. So how do you deal with that? The way the courts deal with it is generally they appoint an expert, an independent expert, independent of both parties, who can then go through and work with the party whose information has been seized in order to identify what is privileged and confidential, and then only make what's relevant available to the requesting party. I think what's missing is guidance from the courts of, well, how do you deal with this in an environment where there's no standards, there's no instructions, on how to determine that. And do people have to go to the expense of getting an independent expert appointed in order to go through this material? Again, I don't have an answer. I'm just raising that as a flag as to some of the issues that are out there. In America, there's been quite a few cases where the courts will look at a way to produce social media information. There's not too many cases, again, of which I'm aware in Australia. So in 2011, in Offenbach and Bowen, the magistrate there conducted an in-camera review of the plaintiff's Facebook account and ordered the production of a small segment of the account as relevant to the plaintiff's physical condition. Another couple of cases there, Douglas and Riverwalk Grill, the court ordered the plaintiff to produce the contents for an in-camera review. After conducting the review of literally thousands of entries, the court noted that the majority of issues bear absolutely no relevance to the case. The court found that the only entries that could be considered discoverable were those written by the plaintiff, which could be in the form of contents made on another's post or updates to his own status. So again, taking up the court's time, I guess, how do we deal with this of making available relevant, discoverable information without a judge having to go through this? Hence, many courts, understandably, have been less than enthusiastic about the idea of doing the parties' burdensome discovery work. In Tompkins and Detroit Metropolitan Airport in 2012, the court actually declined the parties' suggestion to conduct an in-camera review, saying that it's only utilised when necessary to resolve matters of privilege. Another interesting case in the US where one court actually agreed to become a friend of the litigants on their Facebook page in order to determine what was relevant. So, is that going a bit far? Potentially it might be. Third-party subpoenas. This may be necessary where you need to go to, say, the Facebook provider in order to make that information available. In the US, they have the Stored Communications Act. That limits the ability of internet service providers to voluntarily disclose information, hence you may need to get that third-party subpoena, with some exceptions. Again, in the US, there's federal law which prohibits Facebook from disclosing user content and so on, and actually specifically refers to the Stored Communications Act. In Australia, as mentioned, we've recently had the federal government saying that they can acquire metadata that is stored by telecommunications providers. I'll talk about a little bit more about that in a moment. So storing documents on a social media platform doesn't override a party's obligation to produce relevant material. The party must produce information that's within its possession, custody, and control, and a court can compel a party to execute an authorisation for the release of social content. So with an executed authorisation, a properly issued subpoena, and in most cases a reasonably small payment for associated costs, litigation can obtain information related to a social media account. So I guess in summary, before I move to smartphones, it is a moving feast. There's not a lot of case law on social media in Australia. I have spoken to quite a few lawyers just on an ad hoc basis who I guess, use various methods in order to get discovery of social media content. As I mentioned earlier, I think that the first thing is to show that they need that information because it's relevant to the issues in the case. And typically, if in a civil proceeding, if the other side agree that they'll provide it, then they will download it from the social media site and make it available. Obviously, there's still the overriding obligations to the court and the obligation in the rules to make sure that a party must disclose all documents that are relevant to the case, even if it is detrimental to the case. So you've still got those overriding things, and I think in Australia, because we have those obligations, and because lawyers generally instruct their clients to do the right thing, we haven't had too many cases where it's had to be taken to the courts. Smartphones, I won't spend too much time on this. Generally, there's a plethora of computer forensics experts who can obtain information from smartphones. Generally, though, in civil litigation, we find that we don't get too much information from smartphones because the information is generally available from elsewhere. Email is available from an organisation's server, and so on. It's really only in criminal matters or family court proceedings where text messages and other information like photos or things like that, where you're looking for some activity that is contrary to what someone said, or some sort of fraudulent or criminal activity where you need to upload the contents from a smartphone and produce it. Essentially, though, evidence from a smartphone is still discoverable. Obviously, it's still capable of being produced in court. The biggest thing about smartphones obviously is that they're just ubiquitous, they're everywhere, and they contain a lot of stuff. So as I said, contacts, address book, a lot of information is available from an organisation unless you're looking at a person's information that is personal to them. GPS tracking and so on is available, and again, that would be most likely in family court or criminal matters. These examples we have here are more for the criminal type matters, which I won't spend too much time on, but if anybody's interested in practices in criminal law and they need it, please let me know and I can provide further information. There's risks with smartphones. I think it's the same with any electronic device. Any information is capable of being stolen. Applications on iPhones are capable of being attacked by malware. Excuse me. It's always important for users to ensure that their applications are up to date, so that any of those known bugs or backdoors can be closed, and just be careful with information. People talk about apps that allow banking to be conducted on mobile phones and so on, or smartphones. I'll hold this microphone closer. People are saying they're still losing sound. Is that a bit better, guys? Right. All right, so let's look at security and personal privacy laws. So in social media, obviously the biggest risk is the culture of trust. So remember, putting information out there, it's there forever, it's there for the world to see. So I know we instruct our kids to think about anything before putting it up there, which I know can be hard. But there is an obligation, I think, on application developers to take positive steps to protect people's data. So I think Facebook, Google, big companies like that, I think, do take that seriously and do try to ensure that users' information is kept secure and private as much as possible. Cloud computing, in my view, generally is pretty secure. Obviously, anything on the internet is not 100% secure, but I think cloud providers, because it is their business and it's not in their interests to have a reputation that information that they store is not secure, do take steps to put more than adequate security in place. And I would actually go so far as to say that, ask yourself the question, as an organisation, how secure is the information on your servers that sit in the back room in your office that are attached to the internet? How secure is that? Can you afford the firewalls that a cloud provider would pay for and then have what they call, vulnerability tests perform on, which is where hackers are engaged to try and break into the system. Most organisations don't have that level of security. So arguably your information, as long as your contract is adequate and that you've read it and you know what it says, I would go so far as to say that information stored by a reputable cloud provider is a lot more secure than the information out the back room of your office. Simply because I said they can afford better security. You just need to ensure that your data is kept in Australia if that's important to you, that you have access to your data at all times, and that you keep regular backups of your data so that if something happens, the cloud provider goes bust or you can't pay your bill, that you've got all of the information available. Smartphones, if a phone's stolen, generally the information is available unless the phone's encrypted. Malware can be loaded on. As I said earlier, just make sure your operating system is kept up to date and always use a PIN, which makes it harder to get broken into. All right, so I'll turn to privacy laws. The Privacy Act, the Commonwealth Privacy Act, is designed to protect personal information. So there's a definition of personal information in Section 4, which is that it is information or an opinion, whether true or not, and whether recorded in material form or not, about an individual whose identity is apparent or can reasonably be ascertained from this information or opinion. Now that includes information that's included as part of a database. Personal information also includes biometric data about a person, such as their fingerprints, retina prints, body samples or genetic characteristics, and also health data such as medical records are subject to the Health Records and Information Privacy Act, which is the Commonwealth Act as well. So the Australian privacy principles apply to private organisations, and the information protection principles apply to Commonwealth government agencies. The Australian privacy principles are listed. I won't go through them in detail, other than to point out that information must be kept private when dealing with cross-border disclosure of personal information. So that means if your data is going to be potentially stored elsewhere, that you take adequate steps to protect that information. You've also got to take steps to ensure that personal information is kept secure. What can the Privacy Commissioner do if there actually is a breach of privacy? Essentially, they do have powers. What are really the consequences? And does it result in, I guess, large payouts for those who have their privacy breached? Probably not. But Privacy Commissioner has the power to make an apology, to order change in practices, to order access, amendment or deletion of what's been stated, or actually order some sort of compensation. I'm not aware of any compensation orders in Australia that have been significant, so I guess we'll wait and see. At common law, there actually is no right to privacy. Back in 1937 in Victoria Park Racing and Recreation Grounds Co-Limited in Taylor, the High Court there, Chief Justice Latham, said any person is entitled to look over the plaintiff's fence and see what goes on in the plaintiff's land. Plaintiff desires to prevent this, the plaintiff can erect a higher fence. However, in 2003, which is obviously a considerable time later, in the District Court in Queensland, Judge Skane there actually took what he viewed as a logical and desirable step to have recognised a civil action for damages based on the actionable right of an individual's person's right to privacy. So, look, obviously that's just a judge of the District Court, but indication there that a judge might be willing to give that common law right to privacy. We do have the Commonwealth legislation now, so arguably, as long as you can fall within that, you can claim that right to privacy. That's just a bit about that matter. I won't go into too much detail. So what's the situation on privacy internationally? In the United States, nearly all US states now recognise either a statutory right to privacy or a common law. In the European Union, the European Convention on Human Rights contains a right to private and family life, home and correspondence. In the UK, there is the Data Protection Act, and which is important because it has no common law right to privacy either. Canada, no common law right to privacy, although several provinces have enacted a statutory cause of action for invasion of privacy. In New Zealand, the New Zealand Court of Appeal has actually recognised a common law tort of privacy. So privacy, I guess, is one area that has received considerable attention in the last few years. The Australian Law Reform Commission did a report, and that actually resulted in some changes to the Privacy Act with updated privacy principles. They used to be called the National Privacy Principles, and now the Australian Privacy Principles, and just restructuring things and potentially giving a little bit more power, and also recognising those cross-border data flows that do need privacy protection. Offences, obviously there's the rogue using fabricated, manipulated or stolen identities. Obviously we have offences under the Commonwealth Criminal Code, the Queensland Criminal Code, the specific provision of the Queensland Criminal Code for identity theft, and in Queensland it also has an offence for computer hacking. In Queensland, the identification offence includes all of those things, such as stealing someone's name, address, date of birth, driver's licence number, passport number, biometric data, voice print and so on. It also covers body corporates, so anybody essentially stealing a name, ABN and so on can be subject to an offence. The computer hacking offence will cover damage or gains or intends to gain a benefit if the computer is used without the consent of the computer's controller. Misuse of identity includes cyberbullying, posting blogs, interacting on social media. Now the biggest problem about identity theft is actually finding the person. As you know, anybody can create an identity online. There as yet are no regulations around that. It's not like having to obtain a driver's license or a passport where you need several layers of identification in order to get that. On the internet you can still remain anonymous. Now I'd predict that in years to come we will have to have some sort of online identity, but we're a long way from that yet. Cross-border enforcement, privacy, there's a lack of consistency. Some jurisdictions don't actually have a right to privacy, so you've got the problem of, you think you're in one jurisdiction, yet that can be rendered meaningless in another jurisdiction. Offences, they're not consistent across jurisdictions, and an offence enforceable in one jurisdiction may not be enforceable in another. With storing data in the cloud, you may have statutory limitations. So, for example, APRA is required to notify the government of any transfer of data offshore by financial services institutions. Sorry, APRA requires a notification of that. Some government departments may have a blanket prohibition on the transfer of data offshore. You may not be able to enforce remedies in Australia overseas or vice versa. You may be subject to investigative procedures offshore, so someone's data that's stored in Uzbekistan, for example, may be subject to have a regulatory authority seize that information, and there's nothing anyone can do about it. So first they may learn it on the front page of one of the daily newspapers. And obviously finding a nexus between the dispute and the court. So just a bit of few issues to be aware of there. Brave New World, consistent privacy laws across jurisdictions would be nice. Hardware and application vendors to have standard privacy policies that adhere to those privacy laws. inbuilt security for user protection, and laws to protect access to users' data globally. Now, it's interesting on this point. I've seen that one of the global law firms has just invested in a side business which is going to specialise in providing advice to companies where they're doing business in more than one jurisdiction to advise on all of those security and policy regulations for exchange of information. So, you know, if you're a company that has to have servers in countries all over the world, how do you comply with all sorts of regulations because they are so different? Now that's welcome because it means that in one place you're now going to have all the different regulations and laws and policies, so we can start to get some visibility over what's required in order to have some sort of standard. So how you get that when, you know, each country is a sovereign state has a question mark over it, but I think it's a step in the right direction. All right, hopefully we've covered quite a few things there. I'm sorry that we had a few audio problems. I'll see how bad it was. If it is too bad, we may re-record the session and put it up on our website so that you can re-download it. If anybody missed anything in particular, just let me know. If anyone has any questions, please type them in, or there are my contact details. Feel free to send me an email separately. Okay, well, otherwise, if I don't see any questions coming through, so thank you for your time and enjoy the rest of your day.